Hello, I think I'm live. If I am, can you hear me? John. All right, so we have a live stream. Thank you, loud and clear, Dustin. All right, so I already got a couple of questions. Currently in a lawsuit with Velocity. They were obviously represented. I've been given 3 days. My questions are: I owed $16K to Upstart. They wrote off the debt and it was sold, obviously. I've watched your videos on this and still worried if I made the right choice to fight this. I've tried to settle for about 40% with no luck. Where do I go from here? Not exactly sure where you are, but it looks like you're in the pre-trial stage, post pre-trial, and that you have now been given dates. I hope there's some sort of discovery that allows you to ask questions, and also you filed your counter affidavit. I think you did the right choice because the alternative is to be defaulted, and you don't want that. I think you could settle for nothing, but that's just me. That doesn't mean you. I'm not telling you your marching orders. You got to do what's comfortable for you. But unless there's a perfected chain of title, see every Velocity video, meaning your debt jumps from the original creditor to Velocity. They have no case. You, I am sure, have a bill of sale and a thing that says Exhibit K, and that'll say such conflicting information. It's quite easy, but hard to get someone to listen. You just have to be consistent. Your counter affidavit should have identified that if you followed my video. So where you go from here is you ask them to prove all the chain of title. Please show me an assignment with my name and account number in it from here to here to here to here. And a lack of response is the best thing because it's going to happen. They'll fight you on it, but the stuff they fight hardest on is the stuff that you're actually wanting them to fight hardest on. I have no water. This is going to be fun. All right, so that's it. Do we have any questions? Yes, we are a group in New Jersey. Hi. Rock Solid Natural Health. What a great name. Oh, hi, Eva. Yes, hi. Oh, Revelation 13:17 CBDC Watch. All right, so no questions from the crew. So, what are the biggest mistakes people make when they get sued? Number one that came to me at that last question, not including a counter affidavit. What do I mean by that? Meaning, tell your side. If you go, there's lots of services out there. If you go and put admit, deny, the chances of you selling that the way you want to sell it are going to be denied because you haven't explained yourself or why you should win. Commonly, what I do is I have my counter affidavit based on their documents against me, and that is leverage. That's the number one word we've been using the last couple of videos, leverage. So when you're writing an answer, you are creating, just I want that in your head. Why does this answer give me leverage? Admit, deny, don't know, neither admit or deny, gives you zero leverage. Whereas if you be a Parker problem and fill it with their information, and there's so many videos and even free stuff on there. There's a PDF, how to do a counter affidavit, how to do an answer, breaking it down, pointing out their bad stuff. So the more that you create that answer, just remember, it's leverage. Stop calling it an answer. Start calling it a leverage, an answer to their complaint. Act accordingly, as they used to say in debt collection letters. You owe this. You better do this. Act accordingly. They used to have that all the time in debt collection letters. Okay. Hi, Brian. Rox. We emailed our questions. Here's a copy of some of the group's questions. Group. Oops, I'm allowing dead air here. Something about Green versus Portfolio. Green was a fantastic case. That was Miss Green was a pro per all on her own, took it all the way to Virginia Court of Appeals and won, beat back huge law firm and big company, a company that is located in Virginia. So they poured a ton of money into an appeals court, a de novo. Hey, could you take a look at the decision you just clearly found for Miss Green? Do you mind taking a look at it again? All the money of the other side and tons of law firms got this thing pushed away. So the same entire panel of the Court of Appeals suddenly said, you know what? I think Miss Green was wrong. And whoosh, away goes that great victory she was clearly right. But that's what money does, I guess. So there you go. I have an issue with Discover Bank. I sued Discover Financial Services, and Discover Bank showed up claiming incorrectly identified when they weren't even served. I'm not sure legally how they did that. In a sense, they don't have standing to say you don't have standing. But unless there's something legally done, Kim, I'm not sure if you have anything to do. If you are solid on your footing, unless they file a motion to dismiss based on the fact that you've gone against an incorrect party. Remember, if I'm reading between the lines here, Discover Financial Services probably didn't sue you first. It was Discover Bank, and you've gone one step ahead and are going hard in on other parties, which is great. The more noise and mess you make, the sooner someone's going to want to clean it up. So you're creating leverage. So I'd say stand on your solid ground based on just the limited information that you've given me. Pruitt said, hi, I've had a few credit card lawsuits filed against me, but they haven't served me yet. Can I preemptively send my debt validation letter and secure? Never. You can send it. Don't wait. Can I wait? No, you got free time. Two things, by the way. When you are sued, it's not official until you are served. Without the two S's, it's not. You're not in jeopardy. This is a stretch, but the double jeopardy expression you've heard. Well, that just means you're in jeopardy once, and someone's attempting to criminally put you in that same jeopardy, which you can't do. So you're not in jeopardy, using a criminal term, but you're not in jeopardy till someone serves you, be that by mail and be that by personal service. And it must be a proper serve. I've got plenty of videos on. I think one of the videos, it was at the end showed a raccoon stuck in my roof. Not to make light of being served, but one of our members voluntarily agreed to have her video in that video that we did about being served. It was about a month ago, because she was so mad. She had a Ring video of them not serving her, and they filled out a thing. We properly served her. And they described her as maybe 4 foot to 5 foot tall. She's 5'7", in her 40s or 50s. She's maybe in her 30s. Totally opposite. So she had that Ring video really did wonders, and we're in a good position. But look, you are not in jeopardy until you are properly served. So that free time you now have, use it. Send as many letters as you can. And even if, and a lot of times what happens, just telling you from my experience, while you're doing this over here, the attorney has this over here and it's usually wrong. So they'll go, hey, look at this. And you go, well, look at this from your client. That case is settled. So do everything you can in the time you have because it produces leverage. That's the magic word. In fact, everything I do is to, if you think about the prism of looking through leverage, how does this give me leverage? I want you to think that way in your debt collection defense. Getting sued by Key Bank for 20, I wonder if that's New York. I spent a lot of time in New York and Key Bank was a big one up there. How do I prove the debt was securitized? Simply, I used to go and just Google and then read the trust documents, but we've got 21st century devices. Google AI is good for that kind of schlog. Certainly ChatGPT, Claude. With this proviso, unfortunately, there are these things called mirages and they have not worked them out yet. So you have to trust but verify. You got to verify anything legal. I really do my homework. And sometimes ChatGPT actually causes me more work. So ChatGPT is good for skeletons and bones, but not good for muscles and ligaments. So you have to supply that. But it loosens the cat. So that's good. So that would be my first key bank honest answer to you. All right, it's starting to get heavy here. So Riva for all. Hey, their master man Brian. Oh, the coolest Parker since Peter Parker. Thank you. Spider-Man ain't got nothing on you, BP. Thank you. I'm thinking of the Bruce Springsteen song, Eve was tempted with an apple out of Pink Cadillac. But anyway, as far as biting, rock solid natural health. Question is coming up here. 2, how can we get more than the stupid $1,000 FD? All right, so that's the statute FDCPA has not been amended per se. There have been CFPB rulemaking changes, but one of the things no one has done, because there's really no great reason to, as far as Congress is concerned, with their laundry list of things to take care of, is to increase the amount of money you can get on a violation. I used to try cases all the time and ask for per violation, and until somebody said, hey, wait a minute, you can't do that, I may have succeeded in doing that. So, but it's not per violation. It's $1,000 plus attorney fees and costs. However, you're allowed to, and that's statutory. So just showing, let's just say without talking about Article 3 standing, just showing that a violation has occurred and it wasn't, and the bona fide error rule, if you remember one of my videos, has not helped them any because it was a mistake of law, then you get $1,000 or actual damages. Let's say, and this was a common theme, you kept getting called at work all the time, that's 1692C, and you had said, look, I can't do this now, or I'm represented by an attorney, I can't accept calls, and there's evidence of that. It's real easy just to do a log, or I always send a letter, of course, everything's letters with me. And they continue, and then you lose your job. I'd say you're entitled for as many weeks as your paycheck is absent in what's called an actual damages. Actual damages means, so there's 2 ways to get damages in FDCPA. Actual, meaning we have to prove the actual damages, and statutory, where we just have to prove that a violation occurred. So while the $1,000 is limiting, FDCPA still bothers the hell out of debt collectors because there's other stuff going on there. You suit them, their insurance rates go up. They don't want that number of things. They got to pay their attorneys, and it is a leverage device. I'll stop there because we're starting to get full. Casey here from Las Vegas. I'm an engineer working in AI. How can I become one of your test users to help you make the platform work even better? Oh yeah, I got to talk about AI. What am I supposed to say? Okay. I'm sorry, Casey, if I screw this up, but there's alpha testing and beta testing. You're talking about beta testing, the alpha testing of the AI. So this AI platform is basically going to do all the work for you. And I know that how, because someone told me, but I know that how because we got the first alpha testing. So our developer sent us the actual platform and said, go break this, which Casey, I know you understand. Find the bugs, find the problems. So Natalie has been trying to break the thing. And Natalie is a tough cookie. She doesn't get easily excited as I do about things. So when I came back to the office, she said, "This is great. I did this, and it thought for me." And I talked about California. It came in with the California code. He said, "This." She said, "This is amazing. He knows what it's doing." I don't know if it's a he or not, but and it's me. It says Brian Parker. Blah 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 blah. Are there bugs right now? Yeah, and that's the alpha testing. Casey, what you're talking about is the beta testing that I've been teasing you with. It's not a tease, it's happening. As soon as we're done breaking it and our developer fixes it, again, you know how that works. Natalie told me this joke about developers. It said a developer will tell you which say, hey, it's going to be ready Wednesday. They just won't tell you which Wednesday, and that's just because there's bugs and everything. So this is being broken by us as we speak. My philosophy in anything is the bone that is broken once is stronger than a bone that hasn't been broken because it's a calcium deposit, and the bone is actually stronger, maybe. So we're going to break the hell out of this, so it's good for you for the beta testing. I'm sorry if I don't always look at the camera. It's up here, but I'll keep trying to do that. It's bothering my head. So the beta testing is what you're referring to. We will send out an invite. If you want to send Natalie an email saying, I want to be the tester. So what you're going to be testing is you're going to be breaking it and seeing things that we don't. The more people that have fun with it, and it's all our members will get free use of it. Not only are you breaking it, but if you've got a case ongoing and you need something, I watched Natalie use it. She gave it. I don't know if I'm allowed to tell you these facts. I am, because the person told me to ask. So a person sent this fact scenario that's happening to her, and we put it into the Parker ChatGPT, and it just pumped out discovery, an answer, and then Natalie messed with it a bit, and it said, "Whoa, I've got even better stuff." And then Parker GPT gave her all the documents she needed, a new approach to the case. I'm being sued in Los Angeles Superior Court by my ex-friend accountant. He asked me to marry him after knowing me for about 2 years. I said no 3 times. We continue to be friends, or so I thought. Just short of the statute of limitations running out, he hits me with a lawsuit. That's a great fact scenario for a law exam. And I figured it out, one of the ways to approach. I owe him $200,000 in accounting services. I got to do this. Accounting services. I love that. No engagement letter. Natalie thought that was funny because every accountant gives you an engagement letter, and I think it's legal. You have to do that, but she saw it as engagement, as in a ring. So we were friends and exchanged housekeeping, administrative duties, shopping, etc. for accounting work. Anyway, he has not produced any evidence. Judge won't dismiss, though. Judge is also a CPA. Motion for more definite statements. So Natalie put that into, I just call it ParkerGPT. I really use the water. And it came out with just incredible stuff. So she messed with the fact scenario. Boom, came out. I did not know this was possible. So I'm very excited about this. Just let us break it first. Casey Mark. Hi, I'm being sued by LVNV Fund. That's the best thing you can say if you have to be sued, because they screw everything up. It's a very large organization of several levels with a South Carolina attorney running, I think it's Resurgent, and saying several things which I disagree with, if you will. And there's so many hands in the pot at that level that something's always broken. So that's a great debt buyer to be sued by. You can settle that out. They make their own problems. Now, keep in mind, it isn't that they want to make problems, but they just don't have what they should have to sue you. But they don't have to. Up to 9 out of 10 cases will get defaulted. That's what the stats say. Go to Google and find out how many lawsuits are filed and how many were defaulted, collection lawsuits. So I keep sending them certified info about the break in the chain. I think what you mean is you keep sending them certified letters. That is a great little portfolio that you'll have a need at the right time. Plus TV, if I were a part of the program, do we get the AI or ParkerGPT? I apologize for mixing that up. ParkerGPT is what we're all starting to call it now because it's AI with my nonsense and brain and 30 years inside it. So it becomes ParkerGPT. I don't know if I can really say that, but I like the little airplane that comes across the screen. So Reaver for All says, I'm good. I'm happy to help with any of your testing. Coach Nebraska, Brian, I went to court today for Discover Bank and Capital One attorney showed up, judge ordered discovery. How else would you handle this situation? I don't know what it means Capital One attorney showed up, but very, very commonly, and I take advantage of this, I'm going to say to you, I always give you statistics which don't sound as, how could that be true? But I'd say no lie. Well, I'm not going to lie. 9 out of 10 early court cases I go to, but now it's bleeding into really serious motions. The person that shows up doesn't even work at the firm that's representing, let's say, LVNV funding or Discover. Extraordinarily, I think companies are laying off their attorneys, and now these huge contract law firms are being created where you as a debt collector law firm have several, maybe 100 around the state. So you just call the 1099 attorney and that person shows up. Sometimes they go on the same case, a different person shows up every time. And here's the beauty and fun thing for you, they don't know the case. So when you get a chance, don't be afraid because they're going to screw you the best they can at any chance they get. Point out that the attorney does not know the name of the person or messed up the facts. Point it out. They're there to hurt you, and that does make them look bad. They're trying to do that. You want to be a problem Parker. I don't want you to always listen to me because I'm off the board. That may not be you, but it's certainly them. Don't let them get away with that. Go ahead and take advantage of the fact that that person is not knowing the file. That's how I'd answer that. So Teresa Duke, in the beginning of lawsuit, Discover's suing a lot. I was rushed to file an answer on 410, no counter. On 610, they filed their motion disclose, but did not file in 14 days. I'm not sure about what motion you're talking about. If you could just follow up with that. Coach Nebraska, Cap One brought. All right. There should be an assignment of your specific debt to Discover. The rule is, with some limitations on a case called Santander and Henson, if the debt was bought in default, meaning you had defaulted and then Discover bought your debt, then that's a debt collection attempt by Cap One. They have to show an assignment. So use that information the best way you know how. One of the things I have one video on there's 375 videos now. I think one is called How to Make a Creditor a Debt Collector. In that vein, check that out. Natalie just changed the site again. She can't leave it alone. She's always fixing stuff. And she made it easier to see all the companies we sue or sue us and just put it in a long line like a stock market ticker as opposed to having all these boxes on top of each other. So go check that out. Attorney stated they are now the original. Oh, beautiful. But there was no amendment in the case. Good job, Coach. Sorry, not Nebraska. Gosh, I have my glasses, but I also have my vanity. I look like a dork with these on. So, Coach Nikisha, you're in great shape. Go with that stomach. I know what you're thinking. They got to show it to own it. And yeah, there's no amendment. And that's exactly right. You have to produce a set of facts that show you own the document. And they haven't amended. And every state has the amendment rule, whereas you either have a certain amount of time where you amend on your own without permission of the court, or if it's over that time, they have to ask permission of the court. So if they file a motion to amend, this is an opening for you. And if anybody else is hearing that has a Cap 1 case that used to be Discover, when they file that motion, demand of the court, I'm okay with this if they could just show my specific debt transferring, be that problem. Because why else? What other question would you ask? I want to see if my debt traveled. Because you're under this Discover Bank, Discover Funding, whoever it is, DBB Servicing, actually securitized. So someone has got to get my debt out of the secure trust, give it to Discover, then give it to Cap 1. Ain't happening. But be that problem, be that mess, and make that leverage. All right. Kim Johnson, Coach Nikisha, Capital One brought Discover Bank. That's why Cap 1. That was she knows that. I'm the problem. I did not know that. Teresa Duke, can I still file a counter affidavit or amended answer? Always. You just got to do it within the rules. Find a way, because that counter affidavit is everything. You're all talking to me with state questions that I'm not going to be able to answer. Most of my answers are from general stuff or law from the states that I practice in. So don't be using my stuff as legal advice. But my weakness is I'm a problem solver and I want to help everybody. I'm being sued by UHG. They had their second-hand documents, such as a bill of sale, just recently notarized 2 months ago. Yeah, 6 years old. I love it. I think you're already on the right place. Check out my videos if you need another UHG video. I may cause myself problems doing this in that I'm going to do a work overload. But if someone wants to send me their case with the understanding that I'm not giving you legal solutions, I will look at the facts in your case. Let's just do debt buyer case right now. And I'll take the bill of sale. I'll take the weird assignment and I'll maybe do a video on it just for that. So maybe it's a Nebraska case or Ohio case, but the documents they use are all the same. They're usually from New Jersey or Utah. So maybe I'll do a couple of videos on UHG or Velocity or something like that from Texas, from Nebraska or Ohio, where I'm just going to look at the documents today and show you why you can use these documents against them. That's the video I just thought of that. So if you want to send them to me, just don't overwhelm me and make sure they're just debt buyers right now. I have a curious question to see if you've ever seen this. In Nevada, they have a mandatory arbitration alternative. Okay, in district courts for cases under $50K. Wow. Yeah, I've done several videos on this. What I'm here to tell you, my next video, I've got one coming out today, how to settle a debt with a headset Harriet or Harry, and how to settle a debt with a collection lawyer. Those are two videos, but they were really badly titled, so I put them both together, and it basically says how to settle a debt part 1 and part 2 when it's time to settle. So that's my next video. So my point in telling it, my next video will be on the new AAA just came out with new consumer friendly rules on arbitration. So I broke it all down and analyzed it and threw in a case or two for you So when you do go through arbitration, use these rules because it actually gets you out of arbitration. And I'll show you a way. I also have a video, an old one, says treat arbitration like the plague, but if it's mandatory, you have to go. So then I have another video that says arbitration, mediation, case evaluation, how to get through it if you have to go to it, or something like that. Yeah, I wish it was sounded that good, but that'll tell you how to get through with documents and everything. And what I did is in the one about arbitration mediation, if you have to go through it, I created these letters for the arbitrator that he has to answer to show why you have to be there. Can you have discovery? You'll see my video coming up on mandatory arbitration and the new rules, and that should be helpful. Part one, Pruis went through the court records in my county of all the people that Capital One sued and reviewed the docket. It seemed the best chance for a dismissal case was the ones where the client, okay, I'll wait for that. I missed my deadline to respond by a couple of days. Can I still, yes, until you're defaulted, you're not defaulted. And if you file an answer a day or two or three after a default, a lot of times the court will go, because they know most states, the rules are so liberal. If you get in your request to set aside the default, I think within 21 days. So yes, file an answer is what I would do. You do you. You do the voodoo that you do. I went, okay, yeah, missed my deadline. Rock solid help. How about if the judges all avoid the elephant in the room? Brian Parker's hat? No. Chain of title not perfected. How can we make a judge follow law in any court, especially the heart of the violation? Number one, I'm not sure what state you're in, but if you have case law on that, and there's some states that have really good case law. Ohio, Georgia, Wisconsin, to name three, and some Virginia have really good case law outlining how bad assignments are, and just slapping an extra piece of paper on is no good under those jurisdictions. And you can use those courts that are binding in the states, those decisions in your state as persuasive. And then if there's no actual case on your set of facts as far as chain of title, it becomes all that the court listens to. You say, Your Honor, we don't have a case in New York on this, and you do in New York. But in Ohio, in a very similar case, in fact, it's the same defendant, Your Honor, same plaintiff. Here's how they dealt with the unperfected chain of title. I think you'll be okay using persuasive authority, because if it's binding, it's probably in your favor. There's very few cases that go against debtors when it gets that far, because all good cases get settled. I'm going to leave the room for a second to get a drink. Yes, I am wearing shorts. Sorry, I'll be right back. Hi, sorry, I was just talking too much. Says everybody. So I'm doing a double filming right now. I don't know if this mic is working. That's the thing that I can talk on my feet and do all this great stuff. I'm a crappy technological guy. So something's working. God, this probably screwed it up. So how about if the chain? Okay, good. Teresa Duke, thank you. You're welcome. I send you mine if you like. I'm in GA. Okay. Again, I just would like to see your bill of sale, any extra assignments, stuff where they say proves they own the debt when clearly they don't. Again, I can't emphasize enough. The one thing I've learned from doing all this is I'll make these great videos, and then someone will ask a question. I go, I got videos on this, and then it occurs to me there are new members every day or new subscribers. So I worry that I'm repeating myself for those of you that are here. Thank you, but I'm just going to keep repeating myself. That's my rule in trials, as I say in a lot of my videos. When I'm trying a case, I keep saying the same stuff, and then finally I'll look over and there's the lady mouthing the words as I say them. The chain of title is broken. And I said, God, I hope that's the foreperson. And she takes those words back into the jury room. A friend of mine just won a trial against UHG, and it was against his attorney, who UHG uses just for trials. He has like a 99% win rate. He says my friend beat the pants off him, and now, because of some weird quirk in Florida, he's going to get $40,000 in attorney fees. They're probably going to appeal, but it's the funny thing is, I can't tell you his name. His name is of a metal, so now we call him a lesser known metal. So the guy that lost. So, and I remember dealing with him where he's like, look, I got a 99% win record. And then so my friend went ahead and beat the pants off him. And the jury said they saw a perfected chain of title, and they still beat UHG. So that's an interesting. I'm trying to get him to come on and talk about the experience, so it'll be good for you. I don't want to miss anybody's question. I said, received a notice of mailing certificate of service with a case management order attached in Florida. That's where I practice. But just got it yesterday. Can you elaborate on what this means for response time? Florida is backed up till 2028. That's an exaggeration, but I'm trying to make a point. It might not hurt you, but I suspect it does. The first thing you do is send a letter, make sure it goes to whoever's made an appearance, saying, I just received this. So always, when you want to make a point about something that happened to you, imagine taking a picture and handing the picture to someone. That's what writing is. So if you want it to be accepted that you just got this, then your polite, concise letter should have the day stating when you got it, maybe even an envelope. Oh, do you have an envelope with the stamp on it or the time when it was sent out? That would be beautiful. Anyway, just alert the court on the other side so it's on the record. Reaver for all, this is district court mandated alternative dispute. It sucks and always leans toward the collector. I find they suck for many reasons. The one I just went to in Florida, it was a cattle call. There was hundreds of people there. It was a giant CF. And I had to kind of, I can't tell you what I did to get to the head of the line. It wasn't rude or anything. I got to the judge, and this is a contract attorney was handling like 50 cases. And I said, Your Honor, the other guy is in agreement with me. We just want to blah, 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 and move on. And he goes, Bob? I go, yeah. I go, Bob. I didn't know the guy's name. He goes, I go, right? And he goes, yeah, right. So boom, out of there. And I talked to him after. He goes, oh, I'm glad you did that. It was awful and one less case. But it's a cattle call. So your goal should be to get there early. Be a kind of a little pest. Keep going up every 5 minutes. Look, I've been here. Eventually they're going to go, we're going to get rid of this person. It works. I'm sorry. But when you're facing 99 people ahead of you and you've got a client you're representing or yourself, who's the best client in the world, you got to do what you got to do. Otherwise you're going to be there for 3 hours. And they may say to you, come back next week. So another thing, a lot of those things go, do you admit or deny? They try to get a yes or a no out of you. That's fine. Just don't sign anything until you review what it means. And that's as far as the alternate resolution stuff, it's there because the courts know they can push people into doing things and settling cases. And they want people to come together. Sometimes when you come together, you both don't want to be on the cattle call. And they'll go, you owe 1,000. If you do it for 100, let's both get out of here. So there's a good, healthy public policy reason for getting you two together. It's cheaper for the courts, but that's why they do it. I get it. I've never been served. Good. You're not in jeopardy. Hi, Velocity is suing me. They have a bill of sale and purchase agreement terms of Exhibit A, B, C, D. But should I apply the Rule 106 since it's referring? I'm not sure what 106 is. Is it an evidentiary rule? Probably. But if that works for you in your state, any kind of evidence rule where it messes them up, bingo. VA state. Okay, VA is good. Look, check your case law there. In fact, go to the Green versus PRA. While it's no good law, that's where Ohio law is mentioned. Georgia, that's a CACH case. Wisconsin has a great case there. Really good cases there. So, and there's a good PRA case against PRA. So check that out for you for bill of sale. Thank you, Brian. In Illinois, the judge disregarded the governing law and said that he can hear and rule on the case. That's true. But what he can't do is say that your substantive law, which is the governing law of the contract, applies. Otherwise, the whole contract is breached. So I get it. How do you push against the judge? You keep reminding him that, Your Honor, in this case, Georgia law applies or Delaware law applies. How do I apply the substantive law? Because that's what the contract is I'm accused of breaching. They can't breach their own contract and have clean hands. So you got to keep reminding the court. He or she may have just wanted to move you along. But remember, governing laws, I got a video on governing laws. There's substantive law, and then there's procedural law. Procedural law is the signposts. Governing law is the car. And you have to follow the rules of the road, but then signposts say you got to take a left, you got to take a right. And procedural law is we're going to have a motion in 30 days. That's the procedure of filing a motion. But the motion must be based on the governing law. That's the substantive law. So you got to remind the court about that in your counter affidavit, in your answer, and any chance you get in front of the court is the best answer I'd give you. It probably doesn't feel that good. My bill of sale is a pool of different were purchased, blah, blah. Motorhead and lack specificity in Georgia. I've been watching your videos for a few months and already said, excellent. Again, there's some good cases in Georgia. I think it's the CACH versus WIRTH, Worth case. And that will spawn or have other cases. So what I would do if you want to look up a case, and let's say it's a 2000 case, put it in Google Scholar or something like that, and it'll tell you also these cases use that case. Well, they're likely using it in a positive way. So you could have a 213 or a 223 case going, yep, in Smith versus Jones, we applied CACH versus Worth. I think that's the case. So put the case you like in Google Scholar and just see. It's called, back in the day, it was called shepherdizing. When I got a graduate from law school, you went to a library and you shepherdized. You pulled down the actual books that hold thousands of cases and found whether you were going to quote a case that had been overturned if you just looked in the future cases. Google does all that for you. So, judge would not listen to my friend's Truist bank account, would not listen to my friend's Blitz and Gaines, RD attorneys, judge wouldn't let him talk and defaulted him. Okay, I get that. 30 days to appeal and said that he did not read his motion. There's not much I can say about that, given the little facts, but just follow the rules. And I hope that doesn't sound harsh. Follow the rules on how to appeal. Order a transcript. That's the number one thing. All my appeals, and we've been doing quite well on appeals, way above the average of appeals, have the transcript. And if the judge says something dumb, I'll put that at the very beginning of the appeal and keep referring to that. And it resonates with some judges, especially if it's a circuit court judge, let's say in Michigan, the circuit district small claims. They want to bully these guys because these guys want their jobs or they've caused problems with some political party or something. So you could press some right buttons in the appellate court ahead of you by just showing you why you're pissed from their own words. It works. So order the transcript right away. The judge stated he did not. When you do an appeal, there is a list of things that you must include with your claim of appeal. That's good. It's a pain in the neck, but it has to be done. And one of those things is, have you ordered the transcript? That takes a couple of weeks. It's only like $40 most of the time. As long as you can check off a box, I have ordered the transcript. You don't have to have the transcript with your claim of appeal in most cases. Re-asking my question, Coach Nikisha says. Rule of evidence. Yep. Okay. Thanks, Jonathan. Re-asking my question. I see autocorrect. Do you believe I should follow the judge order for discovery, or should I also do most discovery judgments generally occur after discovery? Think about how much sense that makes. You're saying there's no proof, no material issue, let's say, of ownership. Well, if discovery hasn't ended, there's still time to find out whether that's true or false. So most summary judgments generally are bought after discovery. So all discovery, all the information that can be sought to support or deny if it goes against you. So that's why you wait till after discovery. Gabriel, bills of sale need to have full information, correct? Absolutely. Should include your debt and your account number. Never seen it. And by the way, lately they've been putting in, you may be like this or not, they've been putting in addresses inside bill of sales and then say see sale file. And it's always wrong. There's what's called a data extension, .pdf, .gmz. It's always wrong compared to the sale. So I have a video, I think it just is called data extensions. I filmed it on a dark day. It was like really stormy. Like today, we have I don't know if you can hear it, this thunder all the time. So it's a little dark video, but it's really good on data extensions. That's maybe what you may want to check out as far as assignments go. Jeopardizing good times. Only, yeah, okay. Thanks, Eva. If you need a good attorney in New York, I shouldn't say this because she doesn't really do the work that she sounds like she's cut out for. But anyway, my friends, re-asking my question. I see order. Okay. Yes. Do you recommend filing bankruptcy to get out of any debts? That's a great question. Commonly, either someone calls me through the consultation thing I have on my site for 15 minutes or 30 minutes, and it'll become clear to me that there's a lot of debt and few ways I can help them. And I'll recommend bankruptcy, but I will ask, I don't do bankruptcy per se, but I can see it if it walks like a duck, smells like a duck, lays eggs, and I step on them. But the bankruptcy, it just screams out that a person should go through bankruptcy. If you've got 10 to 30,000, it may not be the right move because you can piecemeal a lot of these debts. Just fight them or eliminate them altogether if they're debt buying cases. And now that 30 is down to 20. You can make deals and you won't scar up your credit report as bad as bankruptcy is. With that said, corporations commonly file Chapter 11 or whatever bankruptcies they use and then go on with their life. You can too. You're better than corporations. So it's a nice clean slate. You took a shot. Maybe you started a business and it went south. Been there. So bankruptcy is an option, but just here's the thing I always tell people. Pay a guy half hour as a bankruptcy attorney and ask him, is this right for me? And they're pretty honest about that. But if you suspect, go talk to a guy and then make your decisions. The court said the court hearings were not recorded In that Truist Bank lawsuit, they only record criminal and divorce cases. Doesn't help. Wow. With that said, there are Florida courts that do that too. So just this doesn't help you, and I'm sorry. But as a general, if you think you're going into a case and a court where the judge is not going to be fair, or you just want to make sure everybody follows the rules, I have ordered my own court reporter and let the judge know, yeah, Nancy, court reporting Ross is coming in. Things tend to be a little bit more clearer and on the record, but that's just a future thing. The other side of that is the facts are what you say they are if there's no transcript. Anyway, Wayne DeMarta, the court said that the court here, okay, yeah, bye-bye. Sorry, Gabriel Bahash. Hi, do your docs available for use on your site good in all states, or should I do something extra? Great question. I started this with templates. My thinking was you have to have some mechanism to do an answer. Then I built up the answer with counter affidavits. So use them as a template, but really most, with some exceptions, at most courts, you're being sued 1 through 20 paragraphs. My templates are ways to respond to that. But the emphasis that I like to place and emphasize is build that counter affidavit and build that answer. So it's not admit, deny. It's deny because there's no chain of title. See Exhibit 1, my counter affidavit. And that's something that gives you leverage. So those, today we said we're going to call all responsive pleadings leverage makers. Think about that. Eva Tompkins sent me a smile. Coach Nikisha, whoa, she's all over the place. Thank you, Brian. I just have a million strategies going on in my head. I know that. I go to sleep or try to sleep sometimes, and I just see all these possibilities. I don't want that much anymore because I'm not sleeping for years now, and I'm always thinking about other people's stuff instead of my own. So I've tried to turn that around, and that's the reason I started this website, so I can put my brain and my conscious on KillDebt. And this AI is going to be me. I'm even going to do an AI of me. I guess the rule is they're 95% perfected now. So that's another iteration down the road. So you don't have to look at this face. I love using that line, but the face would look better looking than me, obviously. And probably, maybe I'll even have brown hair and a real beard. I don't know. So how do your docs avail? Okay. Oh, they have the right pro se. I just didn't. Okay. Thank you, Brian. Just have a million strategies going in my head. I can't believe they dropped the ball like that. Guess they thought all pros say don't know what they're doing. That's an important thing you're saying. And I say that you can use that to your benefit. Be careful with that, okay? It's a double-edged sword. Courts will give you leeway to get away with stuff. Let's just say it like that. And as long as you premise it with, look, I'm not an attorney, but because I'm not an attorney, I had to spend 3 hours in the library last night, but I figured this out, Your Honor. I hope I'm not wrong. Be kind of cute about it, man or woman. But if you're too good, you're not going to get that leeway. So it's a balancing act, okay, Coach Nikisha? They have the right pro se. I just didn't take the bar exam. There's nothing stopping you if that is your goal. One of my kids came to me, and they both could do it, about going to law school, and I did everything I could to stop it because you've got to love whatever you choose to do in life. Love it. You don't marry something you like; it ends up in disaster. 2 divorces, but you marry someone or something you love. I love what I do. I wish I loved personal injury. I'd be a zillionaire. I wish I loved criminal law, but it scares me. I wish I would never go anywhere near custody or divorce or any of that stuff. I had this guy next to me, the office next to me, that did custody, and all day long fighting over teacups. People were, I'm not giving them. I'm like, oh, I don't. So when I got divorced, I had with my first wife, who is fantastic. We get along great. I made sure everybody was happy. We both did. We were a model of how to handle divorce situations. We didn't dislike each other. We just needed to move along. And the kids said later on that that was what they needed. So don't, I can't do that law. I can't, I feel bad for the kids. Just because I'm stupid doesn't mean my kids have to pay for it. So I couldn't do that. This is the law for me because I've been there, done that. I mean, I don't do divorce work because I've been there, done that, but I've been in every possible situation and wish I had me or my website. I'm not pitching. You ever look back and go, man, I was stupid or man, I was dumb. Like I really like how my brain is now and how good it is. And how, I just like me. And that's a very new thing. Sorry about this. But I look back on Brian Parker of old and go, God, he was stupid. So maybe that's just getting old. Okay. Here's the link to learn about the AI version. Wow. Natalie had her job again. Natalie's put in a link about the AI. Okay. Yeah, coach. You should be Coach Nikisha ESQ. All right, I'm going to say something about being an attorney. I may save you a bunch of student loans. I have this client that is, I believe she's in her third year. And when you go through something hell, like whether it's basic training or the law exam or law school, it's all the same. It was just horrible, but it's worth it. That's why you keep going. You know how to get through it if you had to go through it again, right? Or take the bar again. So this client who was in her first year when we met, I've kind of given her wisdom and she hasn't felt like I was being judgy because she's going through hell and she wanted to help. And now she's in her third year. And I'm looking at ChatGPT going, does anybody really need to go to college or law school anymore? Imagine coming out of law school, all the debt and everything. And it's not where it's replacing people, and it may never replace people, but these are excellent tools. So I guess if you get the license, you can do a better job. Like I really have improved my response time and the work I put into my cases and my members. But also it also makes me work harder, believe it or not, because you got to fix the mistakes it makes. But I think AI is going to replace a lot of jobs, certain parts of the profession. It's going to get rid of paralegals. That's done. Paralegals, legal assistants, unfortunately, that's what ChatGPT is, and it will be. So maybe this is the best place to be. After all, you're a coach. Okay, Wayne DeMartra. I signed up as a beta tester. I've not heard back from any. I signed up early. Natalie, if you're listening, make sure Wayne gets taken care of there. Trader Bytes. Your info has helped me tremendously. I love that word. I've been sued twice by big banks after I filed my answer and counterclaims along with discovery. I have settled both cases by suggesting they simply. All right, you didn't finish that probably because of the chat, but I can't emphasize it. What I emphasized at the beginning and what Trader Bytes really is saying. It's all about. That's right, leverage. You use their documents against them in the counter affidavit. The word of the day is leverage. That's what that is. Make a great answer. Don't just go buy a service that just says admit, deny, deny, admit, and then leaves you in the lurch. Make it, add some muscle to it. Add some leverage. Okay, Bill Davis. Can the original creditor still report? If you're the Bill Davis that emailed me earlier, there was something, you asked a question or something, but there was no support. I'm like, I know Bill Davis. I hope you're the Bill Davis and I'm answering your question, but you didn't really ask me anything. Can the original creditor still report a charge off to the credit bureaus? Can the original creditor still report a charge off to the creditor? So the Fair Credit Reporting Act governs the credit reporting. Okay. So People look at Equifax and TransUnion and Experian as these big monoliths, and they're just reporting agencies. Think about that for a second. They're not as big. They are big money and all that, but they really don't create anything. But they do shepherd information, and they get sued a lot because it's a subscription service. So if bank A and finance company B are paying them to list stuff, and then you and I come along and go, hey, that's wrong, there's a possibility that the guy that's paying them is going to get favored there. All they have to do is a reasonable investigation, and they'll find ways to say, no, you didn't give me the proper information. But their rules are they have to do a proper, what's called a reinvestigation. To appear on your credit report, an investigation has been done. So anytime you send in a dispute letter, that's called a reinvestigation. That's why it'll show up in your credit report, reinvestigation. Reinvestigation, my first time asking. That's why it's called a reinvestigation. So there are rules. There are rules to this game. They can only, as you know, everybody knows this, they can only be on your credit report a certain amount of time. So if it's within that, let's say it's 7 years, depending on what's being put on there, it can't be beyond that. Check the rules because it just underwent a major change. One of the changes was a lot of medical debt was going to come off. So now, and what was happening is if you got sick and you had medical debt, it affected your ability to buy a car. Think about that. So a lot of the medical debt is coming off now. And a day or two before the final rules signing off and pushing medical debt off credit reports and sending everybody's scores high because medical debt's huge. I'm not taking a position because each side does things I like, but Trump told the CFPB lawyers to go in and not sign the documents, effect and rule and appealed it, and effectively stopped that great change taking place. He had his reason for doing that. I'm not taking a political side. There's things that both sides do, honestly, that I pick and choose that I like. I'm really not a member of one tribe. That's just gray hair. I thought I'd get more conservative and be in one camp. But I like the ability to just get along with everybody. But that was anti-consumer, but there may be down the road a good reason for that. So, but I'm just saying that's what happened. So medical debt and FCRA stuff, your credit reports just kind of took a blow when they could have been elevated. Now you get sick, you can't buy a car in a sense because your scores have come down because of all this possibly unproven medical debt because your insurance company didn't pay it. So a collection agency came in. And then collection agencies were using it as a threat, which they wouldn't have been able to use as a threat had that CFPB change gone into effect. Wayne, we will have your information. We'll reach you soon. Oh, that's Natalie. Bill Davis, after debt has been sold to a junk debt buyer. That's another great FCRA question. So he's asking if something's charged off. So you should have finished that question. Sorry. If it ends up on your credit report by the junk debt buyer, yes, they are one of. You're not allowed to put anything on anybody's credit report unless you fit one of 6 exceptions. You're a credit attorney. You're the creditor. You're the consumer. You're the consumer attorney. I'm mixing this. I'm sorry, I'm mixing this. But anybody that has a business reason, and a business reason is you owe us a debt on a collection, can put something in your credit report. But it's got to be truthful. It's got to be accurate. And that's, by the way, when a reinvestigation is done, the case law says, was the reinvestigation reasonably done for the circumstances? And was it the trade line, that's the thing on your credit report, accurate or truthful? It's quite simple. I got to go up for you, Bill. Hold on. So if a debt buyer puts something on your credit report, okay, I said this at the last, I've said this a couple of times. If a debt buyer puts anything on your credit report, they are saying we're debt collectors, we can do that, or we own the debt now. No, you don't. I would send them a validation letter, and if it's Velocity with Upstart agreement, or Cross River Bank agreement, or FinTech agreement, says we have a registry. We keep we keep all the assignees and owners of the debt in a registry. So I have a registry letter on my, send them, say, prove to me you guys own this debt. And if they can't, and it's on your credit report, that's an impermissible purpose. See, debt collectors go, well, he owes the debt, boom, right on the credit report. Start sending them letters under the impermissible purpose doctrine. Just because, and that's the whole bugaboo. 99% of cases, they don't have the right and the proof, but they figure they don't have to show it. But if their lawsuit doesn't show it, why is it on your credit report? That's a long-winded answer to you, Bill. But it's an impermissible purpose if they don't have true ownership. That's the value of the validation letters. That's the value of the securitization letters. You got a secure trust in it, you won't. That's the value of a creditor letter. That's the value of that registry letter. Send those letters. And if they can't prove they own it, they can't be on your credit report. It's an impermissible purpose. So, Reva, for all, the question that Bill just asked, if the JDB and the original creditor are both reporting the same debt, on this, isn't that okay? I know what you're asking. So you get a debt from Citibank. They generally sell to Midland Credit, and it defaults. And now Midland Credit gets it and puts you on your credit report. Is that double list? No, because, but with this proviso, this caveat, Citibank, who is the original creditor, they're only going to be on there, let's say, for 7 years. Eventually, that has to drop off. Midland Credit can pull your credit and say you owe this debt to them. And what you do is you look for date this was open. That's the start. And look at the date that the Citibank debt was open. It will say scheduled to come off 2027, whatever. So it'll naturally drop off like that because each creditor has a right to put it on the creditor, but that has to drop off by a certain day. Let's put it that way. I hope that answers your question. Is there a way to make case details available to you for educational purposes? I have a hearing Monday in common pleas and going for dismissal request for misconduct. Filed counter on 11 counts. I love the sound of that, but I'm not in your state. I would do a video to your question, but it's too late, so I can't really help you. Motorhead, I use ChatGPT to help me orchestrate. What a great word. He's conducting an orchestra, a debt collection orchestra. I orchestrated my affidavit and motions in my state specifically. I'm loving this. Helped a lot of my defense, but would have had no idea where to start if it weren't for you. Oh, goodness. Is that where you're going with that? Don't do that. I'm happy you're happy. Thank you. Thank you. Thank you. Thank you. I thought you were going to tell me a chat GPT, but thank you. But you know what? If I am Parker Chat GPT and I help you to loosen the cap, but that Chat GPT stuff, like I said, Natalie and I, mostly Natalie was testing it out today. It was just coming at us better than we realized. See, you have a lot of faith in your developer. And quite frankly, I had no belief that what was going to happen personally with me, my voice in that. And it is. And it's pulling California law and this law and that. It's going to be great. Thank you, Brian. I found you through a guy on TikTok. Let's stop right there. I'm just kidding. A while back and have been following you for about 7 months. Love your channel. I'm also in KillDebt. Thank you very much. I hope I may be wrong, coach, but if I think you're one of my members that use it for coaching yourself on how to get through debt or dispute debts. I hope that's useful for that. The Road. Oh, if you've seen the movie The Road and you let's say you're really happy, you had a great day, go watch the movie The Road, and that'll balance you out real good, better than something depressing. God, The Road, great movie, well done. Read the book. I'm not watching that after reading the book, but that's anyway. The Road, Armageddon, no, not Armageddon, End of the World type of stuff. Thank you, Brian. I found you through a guy on TikTok. Okay, I just read that. God, I gotta wear the glasses. I don't know the difference between legal advice and you helping us. What is acceptable to ask and what isn't? When I first read that sentence, I got scared because you should know the difference, meaning, oh my God, am I giving somebody in a different state legal advice? I can't do that. What is acceptable to ask and what isn't? You can ask what I would do in the situation if it was presented to me, but I won't tell you what to do in your situation. I hope that's the best way to put it. With this, one of the reasons I'm getting into this, AI and the internet as the beginning is blurring the lines. Right now, geographically, technologically, educationally, if this is a word, informationally, all the lines are being blurred. There will be states. There will just be states of consciousness, if you will, so that you will be free to get from her or to him or to help her or to help him without having a restriction because you're not licensed here or licensed there. I don't wish for that. I am telling, because I'm an old guy. I spent all those years and all that money and all those student loans to get where I am, and now you can just get, like Oregon just passed a law that said non-attorneys can argue cases in certain circumstances, paralegals. Great. That's a line that's being blurred. No longer do you need to have a license in some cases in Oregon. And that's just going to start expanding because information and education and technology are going to take away or at least blur those lines. So I can give you information, I believe, about what I would do. Act accordingly. But I'm not telling you how to practice law, your life, or your love, or whatever. Do be you. So Natalie put in Motorhead. You can send it to Natalie at KillDebt.ai. Okay, Bill Davis. Sorry, I have to go down. Oh boy, I'm way behind. Okay, LVNV funding removed it after I requested debt validation, but Fingerhut is still reporting it, even though they no longer sent him a dispute letter explaining just that the owner even took it off. Send it certified, return receipt requested, keep a copy of the signed letter. People think, well, I've got a copy of the Word product. No, the signed letter and the green card when it comes back. And you may have a lawsuit if it's still on there when you've given them reasons to remove it. Fingerhut doesn't want to get involved in this nonsense. So dispute. Bill Davis, sorry about it. Don't be sorry about anything. I'm honored that you're asking me questions. What time? I can't be here all night. Okay. We'll send it. Thanks, Bill Davis. They removed it, but Fingerhut is still blah blah blah. Coach Nikisha. Ooh, Brian. Wow, that was a gem. Can you Motorhead? Can you send them impermissible purpose outside the 30-day window? All right. There are two excellent questions because I get to educate, but hopefully not be a snooze fest. In order to sue under the FCRA, and by the way, the FDCPA has an equivalent. I just did a video on this on E8, 15 USC 1692 E8. You can't put stuff. I just did a video on it, on the convenience fees. I'm not sure that the convenience fee video was clear. I look at my video and go, what are you saying? But people get it. So in that case, there was a convenience fee to charge when you paid your debt online to Aquin. I used to sue Aquin all the time back in the day. And they were debt collectors. I'd terrorize them. So now you can pay it online, and they were charging a $12 convenience fee, which we all do every day. The 11th Circuit said, not so fast, Charlie. that's a debt collection attempt. And 1692, because it was a debt that was in default by a debt collector. So under 1692 F1, it says you shall not collect a debt unless it's inside the contract. The convenience fee was not mentioned in the note or the loan agreement from 10 years ago on a mortgage. So they were charging a debt outside the contract by a debt collector, Aquan, that admitted it was a debt collector on a defaulted debt. It's a definition of a debt. So I don't know why Booz, that's it, Booz and Glover didn't do a class action. They started in state court. They may have been fighting a foreclosure, and so they were trying to bully, something I would do. But that's a federal class action all day long. That's a great case to class action the hell out of Aquan. But anyway, that's FA. That's the same thing as that's like a debt collection dispute. So back to my point, when you do an impermissible purpose case, send a letter before you do a lawsuit. You don't have to, because there's no 30-day rule. Unlike most FCRA cases, you got to send in the dispute and they got 30 days to fix. If they fix wrong or don't fix at all and you know you're right, you sue them because you gave them the 30 days. Impermissible purpose doctrine cases, I think they're F, 1681B and 1681F, I think. I might be wrong about that. So I have no notice provision because someone's pulled your credit. They haven't put something bad on there and you're a creditor that they've had and you're claiming inaccuracy or untruth. When someone pulls your credit, that's a hard inquiry for 2 years. And the law says you don't eat that 2 years, 30 days telling them what they should or shouldn't do. An impermissible purpose doctrine case doesn't have a 30 days. As long as you're in the statute of limitations, you can file also without any notice or letter. Belt and suspenders, I send a letter. So the court reviewing this, or even the attorney that picks this up, until you sue, reasonable minds are not going to be there. But once you sue, a lawyer's going to go, oh, shoot, we better fix this. And 90% of cases are settled once the attorney gets involved. So you don't need that 30 days. I say send a letter so that when the court sees that you didn't just sue, you ask them for them to fix. And all the impermissible purpose cases I've done, no one has ever responded to those letters. And that's great because now you can show, well, I tried and I was left with no choice but to sue, Your Honor. So that's it. I hope that's a good explanation. Motorhead, can you send him? Yes. Trader bites. Doesn't the original creditor have to report the debt was sold and the current balance is zero? Great question. I will not tell you yes or no without knowing 100% the answer to that. They just have to be, and here's how I'm going to be an a-hole attorney with you. All they have to do is be accurate and truthful. So I avoided answering your question, but I kind of didn't. What they have to say on there must be accurate and truthful. I hope that makes sense because I don't know the answers to. I have friends that do FCR specifically, so they know the ins and outs. I just do it on identity theft and things like that because there's no doubt in identity theft cases that none of that stuff should be in there. I got to tell you, I did a lot of identity theft cases. There was one case, 15 separate times he was sued and had cases, and his good guy client his credit was shot. We were suing every day, and the checks started to come in for him, and a lot of money. He wouldn't take it. I said, hey, you went through it. He said, you keep it, Parker. I didn't. He goes, all I want is a clean credit report. I want to be put whole the way I was originally, and I get it. My identity theft clients, I don't know any client that's bugged me as the check-in is the check-in. They just want this stuff dropped off their credit report. They'll take the money by and large. But I remember this one, I can still see him, and his name, nicest guy, at least 15, I only have 2 ends, 15 lawsuits and checks coming in. It was a great year. I remember thinking, I'm just going to do one of these cases a year, but it doesn't work out like that. And I got the goal, and we cleaned everything up, and he took some of the money. They're really bad. So I hope that answers your question. As far as I don't quite know, to report the debt was sold, I believe they're supposed to say placed into debt collection or something like that, and then it must match up. It's the best I can do right now. I'm going to find out the answer to that. Trader Bytes. If the debt is being securitized, Kim Johnson asks, are you saying that the debt cannot be on the credit report? Great question. I believe that, and I've started to send letters saying, why is this being on the credit report? It's been securitized. So securitization takes many forms. And so you have a debt, the original creditor sells it to security. So the issue is what is sold. In some cases, the whole debt. In some cases, the equitable part of the debt, the account is kept. So they report on the credit report, the original creditor, that they are, but they don't say the account. Or if the debt has gone all the way over, it hasn't been assigned back after default, I would argue that they have no right to put the thing on your credit. And if they are putting on your credit, it has to be some recognition of why they are on the credit report. But that stuff is developing. Hear me out. With debt buying cases, I have this goal of 90 to 100% debt elimination. They're shit cases, they're bad cases. So they're great cases, but terrible evidence. And you're always going to win. And the debt buyers, that thing has been paid off so many times. By the time it gets here, it's a fintech loan. It was so securitized. They know it. They'll settle it for pennies on a dollar or just eliminate it. With credit cases, those are owned by the people you're suing, and they aren't so happy about paying me anything. But we're getting them down with securitization, sometimes 40 to 30%. And that's what securitization is to me. It's leverage and a way to show the other side that you're going in on some tough topics that no debt collection attorney wants to deal with. So securitization at this point in my life is leverage for you and for me. Does the AI help me compose a lawsuit to sue? Yes. Any advice on unlicensed debt collectors? I've asked that question this week. If you're in Michigan and you are unlicensed, no one cares. Conversely, or ironically, a couple of years ago, I found one that had got a license, and I nailed them for that. Because what the debt collectors found out in Michigan is they're held to a higher standard if they're licensed, and there's no punishment if you're not and operating in the state without a license. It's just ignored. So they all stopped licensing. So it actually, ironically, if they voluntarily got licensed, now they have a standard of care. I believe it's called the Michigan Occupational Code that gigged them, and you could really go after them. So they stopped being licensed. Some states, like Florida, if you aren't licensed, there's a provision in the FCCPA, their equivalent, which is better, by the way, than the FDCPA. And it says if you're unlicensed and operating this in state, you're going to pay and you're going to violate. So every state treats the unlicensed debt collector differently. So it's unfair of me to say it doesn't mean anything, because it could if you're in Florida, and depending on your state, it's really easy to find that out. Bill Davis, okay, thank you. I use Coach. I use your site as a tool. I compare your strategy to my strategy just to see if we're in the same page sometimes. So I use the site as a tool. Love the changes and updates. We're doing it all for you. I mean, that's what I'm saying. Sassy. Oh, SAS. SASS. How does the Capital One acquisition of Discover Bank affect lawsuits? Well, we discussed that earlier. It's a great question. I think it opens up a ton of problems for anybody I'm facing that is Capital One claiming they own a debt they will not be able to prove. A very similar thing, I don't know if any of you know this, Synchrony Bank, they bought a bunch of PayPal debt, and a friend of mine how do I say this, that is in the know about things over there said PayPal didn't assign any of debt to Synchrony, and he knows. So that's a soft spot. That's a tip for you. If you signed up today to watch and you have a Synchrony account, they didn't properly assign, they just were in such a hurry to buy it or something went wrong. And he knows, or she, I'm not going to identify he or she, he really knows. Think about how I would know something if I have a case. Think about how he even knows. So check that out. It's another underbelly you can pierce. It was Synchrony Bank, who are generally a mess anyway. So in my opinion, I may be completely wrong. So Kim Johnson. So if a bank charges a $15 fee to make a car payment, that's not allowed. Is the bank the original creditor or debt collector? Are you in default when you make that, such that it's not allowed in your agreement? It isn't given in your agreement. Now, I just thought of something for you. If you're in Florida, Florida says all creditors are debt collectors. See how that applies to your state. See if your state, for Miss Johnson, or for anybody listening, if your state treats creditors as debt collectors, then, and you've got a default, but it's to a creditor, then that may be a debt collection action that you can sue them for under the State Act. I'll just leave that at the road. I'm in the middle of opposing a summary motion, and I'm really confused about how to present everything, and confused about what a legal argument is and what a statement of facts is. Okay, I'm just going to generally talk to you. Statements of facts are the facts the way you see them. You've already done it if you have a preliminary statement in your template answer or your leverage. Your counter affidavit is exactly what I preach all the time as the defense against a summary motion. It has all the reasons why you should win and how they screwed up. That's your statement of facts. You can do, I did a video against Velocity where I did a chronology. FinTech had the debt March 1st, 2025. Sold it to Velocity May 1st, 2025. Then FinTech sold it to a secured trust June 1st, 2025. So you lay that down, and I put it right in the front under the preliminary statement. No court could not see you got a problem here. Okay, so you lay it down as simply as possible. The statement of facts as you see them, backed up by your facts, their documents. That's your statement of facts. So when you go into how the law is applied, I've got videos on Kill Debt. You apply the facts to the law. The law in James v. Discover says these things must occur. The facts show that that didn't occur. Also, remember this. Most summary motions they put their strongest foot or argument first. The last one is their weakest. So you don't have to do as much work against the weakest. But the goal with the facts in the law is to prove the following: that a material fact, genuine material fact at issue is disputed. What does that mean? Example, there's a dispute as to who owns it. In my chronological scenario, somebody sold the debt to Velocity, and that same original creditor sold it a month later, as absolutely as the facts in most Velocity cases, to somebody else. So there's definitely an issue, a genuine material issue as to ownership. So look at the person that filed against you. They will tell you what the rule is. And then now you know what the rule is: a genuine issue of material fact. Look at their cases. Do their cases apply to your facts? You tell the court, well, that case is wrong, that case is wrong. And I don't know, but this is happening with a lot of attorneys with a lot of work to do are using and depending on ChatGPT, and the cases are false. Check it out. So That's that. I would love a crash course on reading and understanding case law to make sense of cases that hurt you versus. Hey, man, that's a really good video. I could see it really getting out of control and boring for you, but I would very much consider that. I could bore the hell out of you with that kind of thing. I already have too many videos that go forever. But now The Road. I can't stop thinking about that movie now. There's a really handsome actor. I can't, but I don't know if he's still, whatever that means. I think his name is, I forget his name, but he's in some really good movies. Some really good movies. But The Road, it was him and his kid as he's trying to get through an apocalyptic nightmare. Oh, it was so depressing. Because at the time I saw it, my kids were that age, and that's all you think about as a parent with young kids. How am I going to protect them? I used to dream of sharks and alligators chasing my kids, and was this going to happen to them? And I got to make you just get scared as a parent. That's just the way it is. And The Road touched that in me and made me scared as a parent. So that was a tough book and a tough movie. Trader Bytes. It's hard to find any case law relevant to credit cards. Yeah, and it's all negative. Although there is some good stuff, but the case law that I've broken down, you can clearly see that Judge A didn't get it, or the advocating attorney didn't push the right buttons. But it's new stuff, and that's what happens. Bill Davis. Brian, I'm never bored with your videos. I'm always enlightened and educated. Said 3 people. But thank you. Yes. Oh, sorry. Pruess. Vigo. I know. Yeah. Okay. You nailed it. That's who can I do a heart or 100 or whatever to that? Whatever. I don't know if I did that right. But yes, Vigo, is it Stevenson or something? But you're right. He was great. He did that movie, the book or the Green Book or something, when he was driving that gentleman around, an African American gentleman, and he's a white guy, I think, and he sees and he's kind of a racist, and the gentleman in the back, the African American, way ahead of him, sees exactly who he is, and he brings him on the road just to educate him. It's a great movie, Vigo, whatever his name, but he's had some really good movies. His last one I didn't like. I forget what it was, but it was about going off the grid or something. Anyway, I'm now getting bored with boring you. It's been an hour and a half. I would like to end this now, and I thank you very much. There's 25 people. Viggo Mortensen, yeah, I guess, yeah, my memory. If you're stronger than me, go watch The Road, because it is a good movie. The book will scare you. And Trader Bytes, yes, agree with no boring videos. Parker is a good presenter. Okay, I'm going to leave it. I remember there was one Seinfeld show, and George would come up with these killer lines. And I think I don't know if this helps you. You go, hey, the shrimp store called. It's out of you. And instead of walking away because he killed, he kept going. And so Jerry had to tell him, you hit it and move on, right? And so here's the final thing. Someone said I'm a good presenter, so I should walk away now. Eva Thompson, thank you, Brian. Great stuff as always. Okay, I'm going to go now. I thank you all. You're the best, and we'll see you in the videos. And don't forget, KillDebt.ai. Natalie and I, mostly Natalie, are breaking it so we can break it and make it better for you. Hopefully next week, you members will be able to break it themselves. You'll be able to use it. Even though I'm saying break it, you'll be able to use it specifically for your cases and your questions and your letters and your motions, maybe even that summary judgment motion. I can't make you a promise there, but possibly. La Luz. So exciting. We need good Parker training. Thank you. The Road. Thank you so much, Brian. That is so funny because I'm into Revelation. Yeah, I can't get enough of it. So I'm trying to learn the AI stuff to be better because I can't talk about it unless. So I'm watching these videos going, oh, we're screwed. Because it's there if you want to watch it, and you can see intellectually how the second this gets smarter than us, now we just become ants and cows. And what do we care about ants and cows? So yeah, it's out there. All right, the road. I'm excited by y'all. Thank you. We'll see you out there. Don't forget to send me a video if you want me to do one and you think everybody will benefit. So the next one will be on arbitration changes. Then the next one, a member won a case against LVNV funding, and the one with Jack against Citibank was so popular. I said I'm going to do another one, so I'm going to do one with her and her success. All right, look forward to testing too. Thank you guys. Good night. Have a great weekend. I hope you get to relax. I hope you get something about what you want. I hope you get what you want this weekend. And I think you should strive for that. I used to spend hours going, what do I want? What do I want? It was right in front of me. And that's my new expression. Hello, it's right in front of you. So I hope you get what you want. And I hope I'm somewhat able to help you get there. Thank you very much, guys. Bye now. I hate saying goodbye, but bye-bye. I don't know how to get out of this. Okay. Bye, guys. I'm going to try and get out of it. Bye.